you. Minister.
Well, thank you, Mr. Robertson. It's a great pleasure to both serve under your chairmanship, but also have a chance to put the record straight and answer the very sensible points and questions that have been made today. And can I first of all congratulate and thank the Honourable Member for Richmond Park. If this debate hadn't been scheduled, I would have been hoping that somebody would schedule such a debate in order to give me a chance to come and explain the situation. And and also all those colleagues from across the House, from all parties who've spoken this afternoon. I think we've covered most of the points. It's a particular pleasure, Mr. Robertson, for me to be back in this role as Minister for AI, for the Office for AI, Minister for the Intellectual Property Office, as part of my wider role as Minister for Science, Research, Technology and Innovation, but also having run myself a very basic AI drug discovery business years ago. I mean, very basic. It was really an algorithm with an elastic band connected to it compared to the sort of technologies today. But that was deploying very basic early AI in order to look in the pharmacopoeia of failed medicines, quote-unquote failed medicines, to find those that actually are dream medicines for certain segments of the population and try and reprofile them. So, I mean, I've seen for myself how AI properly deployed in a proper ethical framework can be a huge driver for both drug discovery, but also better medicine, in fact, better public services. But also as somebody who, from a family with a lot of interest in the creative industries. My wife is a musician, artist and writer. My brother works in film. I've published a book. So I'm very aware of the balance that has to be struck here, and as colleagues across the House have spoken about this afternoon. And I think it's fair to say that, as a number of colleagues have, that AI is coming at us as a transformational technology at a pace that we haven't, in government, really had to deal with before. I mean, it's the pace, the halving of technology cycles, the speed at which it's maturing and reinventing itself. It is creating some quite big, interesting challenges for both established industries, new industries that are taking shape, and the creators across all different spheres of the creative industries. And we need to make sure we get the balance right. But let me just, in case the bell goes or some other interruption, make very clear that since returning to office, Minister Lopez and I have met very fast and looked at this, and we have written round to make clear to other ministers that we think these proposals weren't correct, have met with a huge response which should have been picked up in the pre-consultation before the proposals were announced, and that we are looking to stop them and return to office, have a rather deeper conversation with all party group who I met with yesterday, with experts in both houses and with the industry, both creators, platforms, publishers, broadcasters, and those digital intermediaries, to make sure that we don't rush precipitately into a knee-jerk move that's wrong, but we try and anticipate the challenges that are coming and get a regulatory framework in the UK that can keep pace with the pace of the technology and the issues that it raises. So I just want to reassure but the Honourable Lady opposite, who's asked that very specific question and brought the debate, that we will not be proceeding with these. And I will go on to answer the question which I know my Honourable friend opposite, or the Honourable Member opposite, is going to ask, which is, well, how did this happen and what are the lessons from it, which I think are worth... Yes, I'll happily give way.
Thank you very much for that welcome announcement. I presume it was an announcement. And could he give any idea, and I understand that it's got to go through a number of stages of interdepartmental consultation, any idea when a definitive policy will be produced?
Well, I mean, theses have been written on whether it was an announcement, capital A or small a, but I don't think I could be clearer that the two ministers concerned agree that the proposals that were submitted and approved and published, they were published after I'd left government, I hasten to say, and it was a period of some turmoil, and I think this is one of the lessons from this is try not to legislate in periods of political turmoil. But the key bit of his question, I think, is when we'll be seeing proposals. My strong instinct is that we should draw breath, take a chance to go through all the feedback from this last few months, and then in consultation, rather more deep consultation with all the various interests, see whether there are some proposals that might command the support that's needed. And I will just say something about one or two of the areas.
And he refers to discussions between him and Minister Lopez, which is enormously welcome. As he's speaking from the dispatch box, is that now government policy?
To be a formal announcement and policy, it has to go through, as he's well aware, as a veteran of these things, government right round has to go through the various committees. That process is underway. So until that is formally confirmed, I can't formally confirm that it is collective responsibility government policy. But when the two ministers concerned are recommending that the proposals have not met with the support that had been expected, I think it's, well, he's just said it's good enough for him. So I hope that'll be good enough for all those listening. I think the real issue, as colleagues have highlighted, is how do we get the balance right in this? And that's why we have identified AI through the National Science and Technology Council, our senior cabinet committee chaired by the Prime Minister, for looking at the big issues that science and technology are raising, which I sit on. It's there to grapple with the really big issues about big geopolitical and big ethical, and let me just finish this point, the ethical issues that some of these technologies are raising. And that's why we are working this year both on a creative industry strategy led by DCNS, but also an AI regulatory strategy, which will set out our approach to regulating AI. Because as the global AI revolution accelerates, we need to be very aware that we're working in a global environment, but we need to set a regulatory framework here that doesn't drive AI creators and investors out. We're a leading AI nation. But we also, I think, have an opportunity to set the regulatory framework in a way that reflects the values that this country is respected for all around the world. And I think the Honourable Lady opposite knows me well enough to know that I'm not somebody who believes that there is a huge regulatory dividend from scrapping all the regulations that were put on the statute book through our membership of the European Union. I think there is a very strong case for clearing up our regulatory statute book. There's an awful lot of dead wood and daft regulations, and it's very unclear. But there is a huge opportunity, as I think I can say, led the charge in my party for saying that actually a lot of the Brexit regulatory opportunities are to set the regulatory frameworks in these new and fast emerging areas, whether it's AI or autonomous vehicles or nutraceuticals or satellites. The creation of regulatory frameworks that command the confidence of both consumers and investors help to position this country as a global testbed for innovation, attract investment, and help us to drive international markets and establish the UK's leadership in standards. So I'm very passionate as Minister for Science, Tech, Research and Innovation that we lean into that piece of leadership, as well as focus on getting rid of some of the dafter regulations, like the one that says that coffee machines have to turn off after 30 minutes. I don't know which statutory instrument committee passed that or nodded it through one day a few years ago, but I mean there are some daft regulations, and the truth is our regulatory framework is incredibly complex for both regulators as well as innovators and investors to navigate. So let me just say a few words about where I think the real challenge is. I'll happily give way.
The Science Minister for giving way. And I think you will find, actually, that rather than leading the way in AI regulation, both the US and the European Union have already made strides in AI regulation that it would be good for us to respond to. But I wonder whether he inadvertently made an announcement with regard to the Council for Science and Technology, which he said the Prime Minister's chaired. Previous Prime Ministers have chaired it, but it was my understanding that with the new version, it wasn't going to be chaired by the Prime Minister. Is it chaired by the Prime Minister?
Well, unless there's been an announcement made in the last few weeks that I've missed, yes. He has the right to depute the chair of a particular meeting, but the point is it is the senior committee of cabinet charged with dealing with science, technology and innovation. And I'm personally delighted that this Prime Minister reinstated it very early, as soon as he returned, as soon as he took office. Let me just say, I think if you look at the rationale of the Intellectual Property Office last summer as it was presented to ministers in good faith, their argument was that actually if you look at what's going on around the world. There are other jurisdictions that have moved very quickly to put in place similar text and data mining exemptions in the EU, in the US, in Japan and Singapore, structured differently, but all are wider than the current UK exemption. So I don't want anyone to think that we were going out on a massive limb. We were making a move in the spirit of other countries. To your point, yes, I'll just finish this on the point about the EU regulations. And there is an irony here in that we helped, we were a very active player in helping to shape some of those EU regulations. And I think the challenge and opportunity for us out of the EU is to take the ambitions that we were pushing when we were in the EU and be able to deploy them more quickly and more agilely and possibly even more digitally in a new regulatory framework outside. I'll happily give way.
My friend is right that there are exemptions in other jurisdictions, but not as wide as the one we've set. The most comparable one is Singapore. And while Singapore has many great qualities, it is not a net exporter of music, and nor does it have a creative economy on the scale that we have it. But I just wanted to say as well that what we've been discussing is the Intellectual Property Office's response to a consultation where it recommended the introduction of these measures. Am I right to take from what he said that the government is now minded not to introduce these measures, and therefore, for the time being, the status quo prevails until such other proposal may be considered?
Yes, that's exactly right. And I'll come to some of the lessons from this in a moment, but I'm happy to confirm that. So in the consultation that the Intellectual Property Office carried out, a number of consultees did make the case that UK copyright law was too restrictive and was impeding investment in AI, and the point made about text and data mining exemptions in other countries. But I actually agree with my honourable friend, the member for Folkestone and Hythe, who has a distinguished record in these affairs as chair of the DCMS Select Committee and in his career, that the regulation must be proportionate and reflect the economy that you're regulating. And we do have an incredibly strong digital creative industry and non-digital creative industry, and we have to make sure that that is appropriate. We did hear rights holders arguing that no change should be made in the UK, but we also heard not just the big AI and tech firms, but researchers in the life sciences, researchers in the social sciences, making the case to us that many of them were increasingly finding problems not with negotiating with the obvious rights holders when they were clear, universities, but material that was available out on the internet and finding it very difficult to find the person to get the permission from, and that was holding back research, especially when working with multiple rights holders. So I think whilst I'm happy to concede that perhaps these proposals weren't correctly or fully or properly drafted, I do think there are some issues that are still worth pursuing, and I think the Intellectual Property Office was asking the right questions, but I think it's more complex than perhaps the original proposals suggested, and that's why we have committed to continue that consultation. Yesterday I was with the all-party group for the creative industries, and I've instructed the Intellectual Property Office to share their analysis of the consultation findings so that we can sit down together and go through what the issues are that we still need to deal with and get the balance right. And when I say get the balance right, I think, and a number of colleagues across the House have referenced this today, there's clearly a difference between those small and sometimes voiceless creatives, whether analogue or digital, but particularly if they're not in the digital creative economy. Some may want to completely opt out and say, I just never want to see my image turned into an avatar, ever. And I think people need to have the ability just to opt out. People also need the ability to license and to be on the front foot and to negotiate terms, which happens. And I think what the Intellectual Property Office had picked up from both sides, actually, is that there's a middle ground of people who don't have a strong organisational platform for setting out the terms on which they're prepared to have their material accessed, and digital creators who are using intermediary AI technologies to create digitally, which is a legitimate activity, struggle to find and to make that interface work. And I think it's in that space that we need to be looking particularly at making sure we get the balance right. There needs to be a balance, Mr. Robertson, between allowing our creative digital and AI sectors small, many of them, and extraordinarily dynamic and entrepreneurial. I was recently in Coventry and met a fantastic, almost underground coding community of teenagers who are doing amazing things. So I think we need to be careful to make sure that that creative industry can flourish, but without trampling over the rights of the creators who may or may not want to have their material used. And if they do, then I think it takes us into a second issue, which is fair remuneration, which I've also stood at this box and discussed with the Honourable Member for Cardiff, because there's an issue about rights, but also about remuneration, and how should we make sure that the smaller creators are properly remunerated. And so I think there are issues that we do need to deal with, and I think that's about the balance, as a number of colleagues have said, the balance between rights and responsibilities and remuneration in this world of digitalisation of content and creativity. I think there are two big lessons that I take actually from last summer. One is the importance of data, and I've started a conversation with the Intellectual Property Office to ask if we couldn't do more to make sure that we've got better data sets on exactly what the situation is with new emerging revenue streams, new providers, new creators. It's an industry that's moving very fast, and there is a slight lack of data for us to be able to make policy on the basis of which bits of the market are working well and which aren't. And it's creating the market conditions, I think, that everyone can have confidence in is the real challenge for me and for us as a minister. I would just tentatively suggest that there may be another lesson, which is to harness the power of digital technologies and digitalisation when doing consultations. I mean, I'm not quite suggesting that we should have run the AI-ometer over the consultation responses, but it's an important point, actually, that in quite a lot of analogue government processes, harnessing smart intelligent systems may provide us with quite a good way of identifying better clusters of feedback in consultations and actually help to democratise the process of consultation. It's a slightly left field point, but I think what I'm trying to signal is, as we think about these industries, we have to make sure we're not just talking to the same people, but we're driving new methods of consultation to keep up with the pace of the industry. So, Mr. Robertson, I think I've detained you probably and the hall enough. I hope it's very clear that we've listened, we've heard, we're absolutely committed to making sure we get this right, whilst we do think that the government needs to be on the front foot in anticipating getting the regulatory framework for this right. Those proposals have clearly elicited a response that we hadn't heard when they were being drafted. We're taking them seriously. The Minister at DCMS and I have made clear we don't want to proceed with them, and that we will engage seriously cross-party with the industry through the IPO and ourselves to make sure that we can frame, in due course, when needed, some proposals that will command the support that they require.
Okay, thank you. Sarah Olney to wind up.